This is chapter 2, video 3. Let's take a look at this question today. What are the 6 guiding principles of the Constitution that replace the Articles? If you'll remember, we left off in the last video with the development of the Articles of Confederation. Yet 6 years after the formation of the Articles, the Founding Fathers determined that that particular government was too weak to see them through. It made them too vulnerable to foreign powers like France, Spain, and even England, who they just freed themselves from, and it made them susceptible to falling apart from within because of struggles like Shays' Rebellion. So again, I want you to recall that the constitutional system that we are currently under was not our first system. It was the Articles of Confederation, and they replaced it with the Constitution. What we're going to be looking at in this particular video is what are the 6 guiding principles of this new constitutional system. Some of these are going to be a little review, even from earlier videos, but they're worth repeating here as key constitutional principles. Others, though, are going to be relatively new, so we'll spend a bit more time on those. The first constitutional principle is the idea of limited government. The Founding Fathers were determined to set up a government that was limited. And under the British system, it too had a limited government because they did have what's called a constitutional monarchy. The principle behind having a constitution, guys, the reason why it's so important is that the powers that are given to the federal government or the national government are only those that are granted to it within the Constitution itself. So when there were a lot of debates forming between the anti-federalists that didn't want this new constitutional government and wanted to keep the Articles or at least some reformation of it, and those who said, no, we absolutely need to replace it with a much stronger national government under the constitutional government, one of the key points of contention was the debate of whether or not a Bill of Rights were needed. Well, the Federalists, again, those who were supporting the much stronger national government under the new constitutional government, argued that a Bill of Rights wasn't necessary, that the only powers that were granted to the federal government were in the Constitution itself. And it's worth noting, the Constitution's only 7 pages long, guys, 7 pages. That's opposed to the California Constitution that's over 200. So to put it in perspective, they argued that you don't need a Bill of Rights because anything that's not written in the Constitution itself belongs to the states and the individual people themselves. Now, we'll see whether or not you agree with that particular principle, but that is why the Federalists said we do not need a Bill of Rights. We're not going to have a Bill of Rights. Obviously, there was a determination there, and they did end up with one, but we'll come back there in a moment. Now, the second constitutional principle here, guys, is social contract. And we spent a good deal of time on that earlier, so we're not going to hit it too heavily now. But it is worth noting that, again, and this is the key principle that I want to point out to you, the social contract is based on the concept that the government does not have the right to do whatever it wants. Its sole purpose, at least according to the people who founded the government, influential people like John Locke and Thomas Jefferson, who followed in many of his footsteps, had the idea that the sole purpose of government was to protect our natural rights. Now, individuals, though, the citizens within that government, too, ultimately have to give up the right to do whatever they want. So in order to receive the protection from the government, they give up that right to do whatever they want and to acknowledge that it's the government's purpose to protect the people's natural rights. But that is an unwritten agreement between those two sides, but ultimately it functions the same way. Because if a contract is broken and the government was the one doing the breaking, then it is the people that determine whether or not that was broken, and they have the right to revolt. And that is tied very closely to another constitutional principle we'll be getting at shortly called popular sovereignty. Before we get there, though, we need to reinforce the point of natural rights. And if you'll recall, Locke defined those as life, liberty, and property. Jefferson did a slight revision of those by defining it as life, liberty, and the pursuit of happiness. Now, these rights are not simply provided by the government. You are born with those according to the Founding Fathers and the principles that they were establishing. So nobody can take your right to life, liberty, and the pursuit of happiness away. You are born with that particular right. So it is the purpose of governments to protect those. But it's a pretty radical idea, because this is where the British and the Americans radically parted ways here. That it was the people themselves that got to determine whether or not government did in fact break that social contract. So we hold that power, not just with the right of revolution, although that's a really big one. And that's a big reason why a number of people still support strong Second Amendment rights, but we'll save that debate for later. But we hold that particular right, folks, in our vote, our right to protest, through petition. When we petition government, we're challenging a particular law or policy, what they're up to. We can assemble for those protests. We can exercise our ability to express our discontent in the press through our speech. These are all ways that the people hold the power. But again, people are the ones who decide to ultimately lift that permission from the federal government or their state governments if they feel that their natural rights are not being protected. Typically, though, that power is not held directly. Popular sovereignty can be expressed through the initiative process, where people are developing laws themselves, much like they did in ancient Greece. So, namely, you guys have heard about Proposition 6, whether or not the California people want a gas tax or something like that. That is not typically something that voters typically vote on. That's typically voted on by legislators or people within the legislative branch. We have California State Assembly members, and we have California State Senators, and we have U.S. Congress members that represent districts within our state, and we have U.S. senators that represent the whole state. We have president or the president, and those people make decisions for us, and we ultimately give up some of our power for them to make those decisions for us. Again, with popular sovereignty, we have the ability to take that away, but much of our power is held in our elected officials, and we grant them that permission through our vote. So just recall that republicanism ultimately is about granting our power to our elected officials, but we may lift that power back through our vote. And finally, folks, the one that we're going to spend a good deal of time on in the latter part of this unit is the notion of federalism. A number of people take for granted that the national government gets to call all the shots within this country, and that is ultimately how it is in a number of European nations and a number of nations, period, throughout the world, actually. But federalism is based on the notion that the federal government has one branch of powers, or one group of powers. I shouldn't say branch, but they have one group of powers, and state and local governments have another set of powers, and that there are certain powers that they share in common, which is why this overlapping Venn diagram, I think, is so helpful. And I would spend some time on this specific slide to see ultimately what powers are shared, which are also called concurrent. Like if I ever use the term concurrent powers, that's ultimately what's stated here. But that is ultimately laid out here. But then you also have powers that only belong to the state or only belong to the national government. Some of those areas, though, can get a little dicey in terms of where that is. For instance, like marriage laws, you guys may have heard about the U.S. Supreme Court case Obergefell versus Hodges a few years back. I think it was 2015. That ultimately ended the right of states to ban gay marriage. They could no longer do that. But states are the ones who grant marriage licenses. So this is where a lot of the debate for that came from. States have that right to determine that. States also have the right to deal with elections in the way that they see fit, largely. But that's going to become a later issue as well with the Voting Rights Act that we'll also be looking at later. The idea that I want you guys to come down to is that this typically ends up in quite a debate, kind of a tug-of-war between federal and state governments. Now, whether or not that's medical marijuana or even recreational marijuana or gay marriage or immigration rights, you guys may have heard about sanctuary states or sanctuary cities. Much of that comes back to federalism. Even Obamacare, I can't remember if I just mentioned that or not. That too is a debate. So much of what we're looking at here is that dispute between federal and state governments, who has the ultimate authority here. But again, let's review quickly those 6 key principles: limited government, the social contract, natural rights, popular sovereignty, republicanism, and federalism. If you had to pick one of those that were the most important, I wonder which one you would say is the most important constitutional principle leading us forward in 2020. I'd be curious to hear what your thoughts are. Until then, have a good day, everybody. Bye-bye.